friends, in this short video, we shall discuss a unique concept of data audit, which is related to DPCMS, which is Data Protection Compliance Management System, which organizations need to maintain. And the reference framework for the data audit would be DPCSI, which is Data Protection Compliance Standard of India. Data audit being one of the most talked about aspects, particularly in the Indian context, requires an understanding of the term as well as the scope of the term. When we talk of data audit, what comes immediately to our mind is information security audit, which is normally conducted on an ISMS or the Information Security Management System, which may be an aggregation of technology, people, processes, all trying to manage information in electronic form and trying to ensure that the information is protected against unauthorized access, unauthorized modification, or unauthorized prevention of access to authorized people. So the confidentiality, integrity, and availability concepts of information security is being addressed through an ISMS, Information Security Management System, and auditors try to verify whether the systems are properly configured for the purpose of information security. This is one kind of audit which we are very familiar with. Another kind of audit could be information systems audit, which may be similar to information security audit, but maybe perhaps more from the aspect of the availability of licenses, the availability of assets in the custody of an organization, and may extend also to the information security. It all depends on how we conceptualize the information systems audit, where we stop at the end of the day in probing a system. Now, data audit, on the other hand, is a term which we normally use for the personal data protection context, or in this context, whatever is required to be done. Now, in the case of information security audit also, we have different layers of audit, like the physical security, which prevents unauthorized nearness to the devices, then logical access into the machine, logical access to the applications, and ultimately the access to the data itself. So there are different layers in which different protection measures are kept in place. The last stage is perhaps the encryption of the data, so that controlling the key for the encryption becomes the control to the unauthorized access to the information. Now, when we talk of data audit, we are not talking only of preventing unauthorized access to data or preventing unauthorized modification to the data, or even preventing denial of access. Data audit has a different meaning in the context of personal data protection. In fact, the withdrawn bill called Personal Data Protection Bill, PDPB 2019, which the government has withdrawn after extensive analysis with JPC and other things, did have a specific mention under section 29, in which it stated that a significant data fiduciary is the term equivalent to data controller, and significant data fiduciary is a data fiduciary who had a certain increased level of operations. So such significant data fiduciaries were required to have policies and get these policies and how they conduct the processing of personal data audited mandatorily once in a year by an independent data auditor. This is what this law specified. So it required mandatory audit and an independent data auditor, not necessarily the data protection officer of the organization. So this was one of the provisions of PDPB, and the term data audit and data auditor were specifically mentioned here so that they have now become part of the legal definition. Now, PDPB section 29 also expanded this concept of what needs to be done by this data auditor by saying that the data auditor shall evaluate compliance of the data fiduciary with the provisions of the Act, including, for example, clarity and effectiveness of notices, effectiveness of the privacy by design policy, transparency measures undertaken, security safeguards obtained, then how they handle data breach, and how they actually keep the records regarding all the compliance measures. So, in a way, PDPB 2019 defined data audit as a function which required checking an organization from the point of view of whether they are in compliance with the various provisions of the Personal Data Protection Law of India. Of course, only for the 7, 8 points are mentioned here, but compliance of these 8 points essentially means compliance of the entire 99 sections which were envisaged under PDPB 2019. Because the moment you use the term privacy by design, it encompasses all aspects of compliance. So therefore, this data auditor under PDPB is expected to be a person who verifies clause by clause the compliance to the Act. So this is a purely, you can say, legal compliance verification. Of course, in a technology environment, so the person has to undertake a techno-legal compliance check. Now, auditors look forward to some kind of a reference framework to make their work easy. We have, of course, heard of ISO 27001, a very popular framework. We have also heard of ISO 27701 and very recently 17428 IS. Now, ISO 27001 was meant to be an information security related, you can say, nearly a standard which could ideally protect the compliance related to confidentiality, integrity, and availability of information. And generally, it is considered as the best practice, and people accept that ISO 27001 certification is indicative of a good practice of information security, for which there are accredited auditors who have a definite process of auditing as per the guidelines of the ISO organization, and based on that, they conduct their audit and give whatever certification they want to give. Now, ISO 27701 became an extension of 27001 because 27001 did not address privacy-related issues properly. Though there was a mention about legal compliance, normally the ISO auditors are not legal people and their compliance scope was normally limited to verification of licenses and copyright kind of legal issues. They did not go into the deeper aspects of Information Technology Act compliance or even trademark compliance or patent compliance and so on. Now, 27701 added a few points from the privacy area, such as whether the organization has an informed consent mechanism, whether there is a management of data subjects' rights, and whatever GDPR generally described as the requirements. But 27701 was focused only on GDPR, and GDPR is a law which applies to personal data protection for information which is collected and processed in the EU region. Now, IS 17428 was an attempt to have a similar framework of reference to the Indian system, but it did not fully satisfy the requirements because it continued to only look at the GDPR as a guideline, and there was an inadequate appreciation that Indian laws are to be considered as primary and other laws has to follow. It is not the other way around. So a company in India is expected to be compliant with Indian laws and also compliant with the external laws like GDPR if they are exposed to the GDPR kind of laws by processing EU related data. Many companies perhaps looked at it differently, that they have to be first compliant with GDPR and then it is optional to be compliant with ITA 2000 or something like that. This kind of an approach will not work in the Indian legal system, and perhaps that focus was not fully evident in the other frameworks. Looking at the inadequacy of all these frameworks like 27001, 27701 or 17428, we decided to adopt a different made in home kind of framework, which is what we have called as DPCSI or Data Protection Compliance Standard of India. One of the fundamental principles behind this DPCMS is that as a company, I would like to focus on the responsibility of complying with the law. I don't want to be too much worried about interpretation of the law. When it comes to privacy, we know that even the 9-member Supreme Court bench could not actually define what is privacy. They only said information privacy has to be protected as a right of choice. But beyond that, even the legal pundits are unable to define the concept called privacy. So if I am a company and I am a CEO of the company, I cannot go about saying that I will put up a system which is a privacy compliant system. I will have something called PIMS, Personal Information Management System, which will protect the privacy of people, both my employees as well as outsiders. It is a onerous responsibility to take on such interpretation. We expect that the government of the land has to take the responsibility of interpreting what is the privacy right which needs to be protected, and in the context of information privacy, what are the responsibilities of an information processing organization. So the lawmaker should take the responsibility to protect the privacy and make an appropriate law, and the company shall take care of the responsibility to comply with the law. That is why we have called this as Data Protection Compliance Management System and not simply Privacy Compliance System or Information Security Compliance System. They are all much weaker way of expressing what is practically possible in a corporate scenario. Now, if you want to be compliant with the law, and if the law is compliant with information security and privacy, then there is not much of a difference between what we are saying and what perhaps could be done by saying that we are protecting privacy. But it becomes a little more transparent way of telling the public that I am in compliance with the law. If you have any disagreement with the law, I am not the person with whom you have to fight. You have to go to the court and fight that a particular provision of the law does not protect your privacy. So that way, companies will be freed from needless, say, brushes with the data principles or data subjects on interpretation of a complicated principle called the privacy. And this DPCMS has certain unique features which are not evident in many other frames of reference. But these are all logical things, and any intelligent auditor following any kind of frame of reference must take this into account. But here, what we have done is we have specified this as a requirement under the DPCSI, which is a standard, and make it necessary to be complied with for the purpose of audit and certification. Currently, of course, certification is done under the system promoted by FDPPI. The system is yet to perhaps be broadly accepted. We hope in due course it will become a code of practice for auditors, and probably it will be universally adopted. Now, the three important aspects, uniqueness of DPCMS, I would like to highlight are: one, we are trying to say that visibility of data valuation is an essential aspect of data management. If the organization does not know what is the value of the data they are protecting, there will be inadequate efforts for data protection. So data has to be valued, and that value has to be visible to the management, probably either as a footnote to the annual reports, or as and when possible, incorporating it as a contra financial item in the balance sheet itself. So visibility has to be brought into data valuation is an important aspect of what DPCMS believes in. Second is it believes in distributed responsibility, where every system owner is a compliance officer for his domain, and the so-called data protection officer or any other person who has the specific responsibility is only a person who can manage the responsibility of the hundreds of the employees. It is again impractical to expect that one data protection officer sitting in one place will be able to control the activities of happening in the computers of multiple people, particularly when some of them are working from home and using their own systems, their own mobiles, and so on. So distributed responsibility by specification in the standard is one of the unique features of DPCMS. Third is that whatever compliance measures are taken, it has to be measurable. The Indian law mentioned something called Data Trust Score, DTS, and that has been brought into the DPCMS as a mandatory requirement, so that every auditor will measure the compliance and then come up with a DTS score. And without a DTS score, the audit is incomplete. Of course, we have given enough provisions for flexibility, and probably this system is a good hybrid version where the organization will have flexibility in implementing these standards based on its own risk perception, and the auditor will respect the organization's say viewpoint, and then audit first of all on the basis of the organization's accepted data protection requirements, so that while the standard talks about certain 50 model implementation specifications, the management may try to reduce that 50 into 40, 45 or something like that based on their context. And the auditor, if he is satisfied about the general logic behind the approach of the management, will accept that as the adopted implementation specification and complete his audit. But at the same time, we are expecting that the auditor will make his own assessment on the 50 model implementation specifications which are part of the DPCSI program, and then arrive at a score, and that score will be entirely based on the auditor's evaluation of the company's requirement of compliance over the 50 model implementation specifications. So there could be some deviation between the model implementation specification and adopted implementation specification, and because of which the DTS may suffer. But to what extent the DTS can go down is something which has to be evaluated on a case-to-case basis. Now, these compliance frameworks, before it has come to this DPCSI, we may say it has evolved initially from what was referred to as IISF 309, that is Indian Information Security Framework, which was purely for ITA 2000 compliance. That is, after ITA 2000 was amended in the year 2008, I had actually revised the requirements of information security compliance according to ITA 2008, and that framework was called IISF 309. Now, that actually was upgraded into PDPSI, which is Personal Data Protection Standard of India, when the government came up with initially PDPB 2018 and then PDPB 2019, the first version before JPC 2 made some major changes. Then the JPC brought in a concept that this Personal Data Protection Act should not restrict to personal data. It should have some elements of non-personal data protection also. So PDPB 2019 became something like DPA 2021 as recommended by the JPC, which also has now been withdrawn. But that was an interim status of the law. At that time, we also revised PDPSI and made it into DPCSI, which is Data Protection Compliance Standard of India, which in a way is PDPSI plus IISF 309. That is, whatever is required for protecting the personal data as per a law like the PDPB 2019 needs to be complied with, and simultaneously, whatever is required under Information Technology Act 2008 version should also be complied with. So DPCSI is a comprehensive compliance framework which tries to take care of the compliance requirements of two laws, basically. One is the Personal Data Protection Law and the ITA 2000, which is a Non-Personal Data Protection Act. So far, it has also been the Personal Data Protection Act because of Section 43 capital A there. Now, once the new Data Protection Act comes, we expect that 43 capital A will be deleted from ITA 2000, and whatever is required to be done under 43A will be finding a place in the new Data Protection Act. So DPCSA will include all those prospects of the PDPB 2019 regarding personal data protection, and it will also involve certain aspects of non-personal data protection and perhaps even non-personal data governance, as was recommended by Chris Gopalakrishna committee, which falls into the area of data monetization. So DPCSI will cover the personal data protection requirements, non-personal data protection requirements, and governance of personal and non-personal data. Normally, governance of personal data is the compliance aspects which are there in the data protection regulation. That is the principles of collection, processing, and how it can be disclosed. These are all the governance matters regarding personal data. Similarly, personal data, non-personal data governance could involve the protection of the interest of a company for its own data and prevention of any crimes, so that in a law like Section Information Technology Act, a section like 79, which requires organizations to be following what we call as due diligence, that is complied with. That is part of the ITA 2008 compliance. So the recent certain guidelines as well as the data intermediaries guidelines, they all come as part of the requirements of IISF 309, which has to be combined with PDPSI requirements, and the DPCSI will become the comprehensive law. But of course, we expect that most of the companies will say that I am already ITA 2000 compliance, So therefore, we are actually presenting the DPCSI with an extension kind of a requirement, that is, look at personal data protection requirement under the new law as the immediate requirement, then look at the new guidelines of certain as well as the intermediary guidelines as factors to be brought in. And we hope the company is already in compliance with ITA 2000 in respect of the other aspects of law. Of course, if companies are not currently confident of what they have done for ITA 2000, they can go for the complete package of DPCSI, which is a complete Information Technology Act compliance, including of the certain guidelines and digital media intermediary guidelines, and also the new Data Protection Act as and when it comes. That is how the DPCSI has evolved over a period of time, and it will serve this society. Now, how will this translate into actual practice? We have to discuss more about this. FDPPA has done its part by linking this to the code of practice, which the law permitted under section 50 of the PDPB. And we also have trained more than 100 data protection auditors with a knowledge of the Indian law, the international law like GDPR, CCPA, and other things, and also the data audit skills. We have done what is required to create an ecosystem by accrediting some data auditors who can undertake the data audit based on the current data protection law in India. And we are hoping that when the government comes up with the new Data Protection Act, we will make whatever changes are required to be done in the data protection DPCMS or DPCSI standard and adopt it to the requirements of the new law. Now, as far as the professionals are concerned, we are going to have a discussion in IDPS 2022, where perhaps we will try to gather the views of all the professionals and see how FDPPA can take this unique concept forward. As I want to reiterate, this is a made in India concept for data audits, and it has the necessary potential to be better than any other international frameworks. And in fact, it will be made in India for the world. Initially, of course, it may be made in India for Indian companies under the Indian data protection law. But this DPCMS has been constructed in such a manner that it is a unified framework which can simultaneously address the requirements of Indian law as well as the requirements of GDPR or other regulations. And therefore, in due course, this actually may become made in India for the world personal data protection framework. And we hope that other professionals will help us in enriching this framework and make it more useful to the society. Thank you. I look forward to having